born in the United States. We're going to skip all the way down. They always want you to give, in the beginning, they want you to show the stuff that the states create. Your evidence will be returned to you if it is not damaged, altered, or forged. Submit an original or certified copy and a photocopy of the front and back if there's a printed information on the back of one of the following documents. A U.S. birth certificate that meets all of the following requirements. So, although you were born in a state and in a county, they call those U.S. birth certificates. It was right in front of it the whole time. So if you show that document, you're actually showing a U.S. citizen. That's, although I've been showing you guys how to get a passport as a national through your affidavits and stuff like that, really this is saying show us a U.S. birth certificate, right? Now, another U.S. birth certificate, but they call it a naturalization or getting naturalized into the United States. That's another form of a birth certificate, meaning that person was born into the United States the minute they took that oath to become a U.S. citizen. All right? So a U.S. birth certificate that meets all of the following requirements: issued by a city, county, or state of birth. Name, list date filed in registrar's office must be within 1 year of birth. Shows registrar's signature and the seal of the issuing authority. They'll accept that. So when creating your documents, you can create your documents under these guidelines. And I'll show you how to substitute registrars and all of that stuff when I show you the templates. Fully valid, undamaged U.S. passport may be expired. Consular report of birth abroad, a certification of birth abroad, certificate of naturalization as a citizen or citizenship. Those are their documents they want you to show. So now, secondary documents may be submitted if the U.S. birth certificate was filed more than 1 year after your birth, or if no birth record exists. For no birth record on file, submit a registrar's letter to that effect. For both scenarios, submit a combination of the evidence listed below with your first and last name, date of birth or birthplace, the seal or other certification of the office if customary, and the signature of the issuing official. A hospital birth record, you can use that. An early baptismal and circumcision certificate. So that means if you have a child, you need to, if they get baptized, you can submit that, but it needs to be early, meaning within 1 year of that actual performance of the baptismal or circumcision certificate. Early census, school, medical, or family Bible record. They always put the good stuff at the end. Family Bible records, they'll accept that. Insurance files or published birth announcement. Oh, wow, see, even saying announce the birth, such as a newspaper article. So that's something that used to be common, announcing birth, announcing marriages. Now, the only thing they really used to see most announcements is about somebody dying. They'll put that they still do that commonly. They haven't changed that practice at all. Why do they do that? Because they want your creditors to know you dead and they can go after the next of kin. All right? Notarized affidavits or DS-10 birth affidavits. You can do a DS-10 birth affidavit. Or of older blood relatives having knowledge of your birth may be submitted in addition to some of the records listed above. So that right there, that last part, all the good stuff is always at the end. For all of you, like, well, I'm 100 years old. How am I gonna prove my birth? I already got a birth certificate. Well, according to this, you can create your own statement of birth, long as you get some witnesses to certify that, to attest to that. You see, they will accept that. So now, why do you need to do this? Why? Because now you're separating everything from them. When every document you're submitting is your document that you created. Now, what do you need to do in order to make this a document that they will accept? Let me show you. You share the screen again. I'm sharing. Where's my? Okay. All right. Let me close this out real quick and get what I need up. All right. Shit. 17. I think that's what it was.
Should be 28 USC.
28 USC. Yeah.
17.
Something was wrong. 28 USC. Government records and papers. Let's share that screen. It says books or records of account or minutes of proceedings of any department or agency of the United States shall be admissible to prove the act, transaction, occurrence as a memorandum of which the same were made or kept. Properly authenticated copies or transcripts of any books, records, papers, or documents of any department or agency of the United States shall be admitted in evidence equally with the originals thereof. This section does not apply to cases, actions, and proceedings of which the federal rules of evidence apply. So any government document that is authenticated is considered as the original, right? That's one of the laws on there. So another law is, let's see another one. 8 USC 1104. Let's look at that. 8 USC 1104. Powers and duties of the secretary. So this is the law for the passport, authenticating your passport or administering passports. And then there's, let's see, what's another one? 5 USC. Trying to find a good one. Well, basically, all of these laws talk about what's evidence. Once you authenticate something, it is considered a fact, and you could use it as evidence of anything. So you're going to create your documents, which I'm about to show you. I'm going to show you the documents. Let me share this. First, I'm going to show you the birth certificate. You have to go through something to accomplish something. Say it again. You have to go through something to accomplish something. Unfortunately, a lot of people are not willing to go through something to accomplish something. It's too hard. That's too much. I hear people say it all the time. Man, that stuff you do, I couldn't do that. Working that hard and making all those phone calls, get those loads. I can't do it. That's too much. Basically what they're saying, it's easier for them to go work for somebody and be told what to do. That's what's easy. I think they just be talking when they say that. They don't really understand what they're saying. It's like Christ said when they had him up there crucifying him, and he said, forgive them, Father. They know not what they do. And I'll say to that, forgive them, Father. They know not what they say. They don't know the consequences of their very words. They don't know. It's that simple. Do you realize that you're receiving your reward of every word that you utter out of your mouth? There's a saying in the church, power of life and death is in the tongue. And that is very true. The power of life and death is in your tongue. The power of success and failure is in your tongue, in the words you utter. Not just the words you utter, the words you think. Because the thinking of the words come before you actually speak it. You have to double down on it, meaning you have to contract with the word before you speak it, right? You think about it, hey, this is what I'm thinking, and you speak it. You think about it, then you decide to speak it. You create a contract with your consciousness. Oh, I accept what this is as the truth, and I'm going to speak it now so that I can solidify it and see that it comes forth. It's time for you to live out your purpose. It's not for me to decide what your purpose is. It's for me to just tell you, go for your purpose. Everyone has purpose. Oh, no, I can't think of nothing. No, the reason why you can't think of nothing because your mind is so convoluted with all of the polluted information that you received from the day you was born that it's covering up those treasures, that inheritance that God had for you. That's why I said it's already there. It's just you can't see it because you're looking at what man showed you. Soon as you peel that back, you'll see it. But it takes putting forth God first for you to see it. Then you start opening, wow, I could do this. I could do that. It's like a miracle. Once I get ideas, my mind is motivated on ideas, stuff just pop. My favorite technique to make stuff pop is once I get that first idea, move, stop playing. Too many of y'all playing. Y'all call it planning. I call it playing. Planning and playing seem to be right in the same spelling categories. Move around a few words. I call it playing. Yeah, planning is good in some circumstances, but sometimes you get an idea, you just got to move on it. That's why Christ said, be like these children, and then you can enter the kingdom of heaven. Who you listen to, who you choose to take advice from, inadvertently or not, directly or indirectly, affects the outcome of your ability to level up. Sometimes you'll take advice indirectly just in conversation, like with family. They're talking about their job, they're talking about all of these different things and how you need to go do this and do this. And you're a person standing there with big dreams and they're talking about 9 to 5s. There's no one in that circle that you can connect with about your dreams and where you want to go. So if you hang around that long enough, you'll start to say, you know what, maybe I need to go get this job just to be safe, and I'll work on my dreams later. I'll work on my dreams in the spare time. I'll work on that business that I know will make me multiple millions of dollars in my spare time. And the insanity of doing something like that, listen to me very carefully, the insanity of doing something like that is this. You have these big dreams and you want to open a business, whatever it is, and make millions of dollars. Yet you take a job where you know you're not going to make millions of dollars here. You know there's no way possible you can make that kind of money. You only can make that kind of money for the boss, whoever owns the company. You can be a part, one of the cogs in the wheel or in the machine, the 9 to 5 machine, one of the cogs of many other parts to make them millions of dollars. But yet you'll say, I'm going to work on my business in my spare time. This is my side hustle. Let me tell you something. That job should be the side hustle and your business should be your main hustle. All right, what's up? Y'all should be able to hear me. I'm just checking my mic. Mic check. Can y'all hear me? All right, let's see. Check the chat. Hey. All right. It looks like y'all can hear me. I just want to make sure they said I'm clear. Thank you, ND Circuit. Yeah, I had to start the show at 7:30 because I had to pick my son up from the truck stop. Yeah. So I apologize for the late start. So I told you yesterday that I would talk about article called a special proceeding, which is Article 78 proceeding. That's a special proceeding. That's how you have to, like, when you lose in the administrative courts and you want to appeal their decision, but you have to exhaust the appeal process in those administrative courts first. I had, it was a couple of weeks ago, I found this information, and for some reason, I can't. I'm gonna try to find it now. Let's see if I can find it. Because I like the page that I found. It was on the New York website. And it gave an overview of everything. And it actually mentioned this Article 78 proceedings right on the page. It was one of those things that showed you how to do whatever, told you what to do. And then they stuck that Article 78 proceedings at the very bottom. Y'all know what I say, right? The good stuff is always at the end because they know people don't really read. And for some reason, I can't find that actual page because I read it and it actually, let me see something. See if I can. It just keeps bringing me to the website, but it's not bringing me. I can't find that particular page that. Let's see if this one is gonna do it for me. Next to me. Oh, thank you. Got it. Guess it's texting me about the sound. And I'm trying to see if I can. Maybe this is the Yeah, this is the page. Okay, I found it. See, they buried it in. I'm gonna give you a link in the chat. I found it, man. I know. You know what? This stuff is try to get you. Let me put it in the chat. Yes, hit that thumbs up. Hit the thumbs up. Son of the One True King says, hit the thumbs up. Follow his instructions, please. I appreciate it. Somebody said the music, Beth says the music is louder than me. So let me turn that down. I know how to fix that. That should fix that. That should fix the music. All right. So here it is. I'm going to share the screen right now. There's a way that I want to let me get this off the screen. So here it is. This is the page. Dispute a ticket. So they give you all of the quasi ways to dispute a ticket. You must request a hearing within 30 days after the ticket was issued to avoid paying the late penalties. You can dispute a ticket online, by mail, via the pay or dispute mobile app. They even got an app now. If you cannot conduct your hearing online, by mail, or via the app, you can schedule an in-person hearing or visit Department of Finance Business Center between the hours of 8:30 a.m. and 4:30 p.m. And if like any governmental office in New York, that's probably going in will probably be an all-day affair. And then it says important information about disputing your ticket. They call it a dispute, right? You must meet all deadlines. Contacting anyone other than the Department of Finance does not change the deadline. If you request a hearing after 30 days and an administrative law judge finds you guilty, you will have to pay late penalties. Please note that appearing at an in-person hearing does not increase your chance of getting a ticket dismissed. The Department of Finance encourages customers to use online, mobile app, or mail hearings to save time over in-person hearings. All statements you make and information of documents you submit must be true and accurate to the best of your knowledge. Any false statements made may subject you to the penalties. And they go on and on. So we really want to go into, because most likely they're going to screw you in these proceedings. So you want to go and find out, appeal a hearing decision. Oh, before I get into that, I didn't appropriately do my intro. I just realized that, right? Peace, everybody. Thanks for coming into the show, and shouts out to everybody that's in the chat who's giving a thumbs up. It is Tuesday, October the 22nd. 9 days left to the month. Already, November is here. It's just like things are done for this year. Now it's just wrapping things up. But if you have things that are incomplete, keep it going. Keep moving. Even if you just starting. And you wanted to start at the beginning of the year, you didn't. So keep moving. All right. The key is to keep moving. All right. So let's get back to this. If an administrative law judge, and they give them administrative law judge, so you're in an administrative court, finds you guilty at a parking ticket hearing, you have the right to appeal the decision. To request an appeal, you must file a parking camera violation appeal application by mail within 30 days of the administrative law judge's hearing decision. While waiting for your appeal decision, penalties and interest may be added. So you still got to pay this thing. See this? See that you're appealing and you still got to pay these people. Towing and other enforcement actions may also be taken. You can avoid this by paying the total amount due before requesting the appeal. If an emergency prevents you from attending a scheduled appeal, you cannot notify the Department of Finance in writing. You must notify the appeals board by calling 212-361-5990. If you do not notify this, you will lose the appeal appointment and will not be able to reschedule. If you have questions, call 311 24 hours, 7 days a week. If you're outside of New York City, call 212 New York. For TTY service for the hearing appeal, call 212-639-9675. So that's what they're saying. Wait, hold on. Let me get over here. More information. This is where it starts to get to the part I want to really talk about. The appeals determination. The appeals board will make one following decisions. One of the following decisions. Affirm, uphold the original hearing decision, meaning they will agree with that administrative court. Modify the original hearing decision. Reverse the hearing decision. Return the case for completely new hearing. Decide that there was no issue on which to base your appeal. The appeals board determination will be mailed to you. If an appeal results in a reduction of the fine or a dismissal of the violation, the Department of Finance will automatically mail the refunded amount within 30 days to the person who requested the appeal. You have the right to file an Article 78 proceeding to challenge the original hearing decision or appeals determinants by visiting the clerk of the Supreme Court for New York County at 60 Center Street, room 116, New York, New York, 10007. For more information, call 646-386-3025. So, after you go to this quasi court to fight them, and you got to exhaust that avenue first. Well, most likely you will probably lose because those courts are about money, equity. They're just there to charge you a fine, you pay it, and that's it. Most people just pay fines and keep it moving. Most people do not want to even go through the process of fighting this. This is how I even got here, because the conversation I had with someone did not want to go through the headache of fighting them. You know, how do you fight them? Everybody says you can fight them, but how do you fight them? And so while we were talking, I just went on and typed in, that's how I found this page again. How do you appeal a traffic court citation, New York City traffic citation? And this page popped up for me in the Google search. And while we were talking, I was reading, I was skimming through, and I noticed this Article 78 proceeding. And then when I looked at it, I said, this is what they call the Article 3 court. You know, Supreme Court is the Article 3 courts, meaning they are the courts with original jurisdiction. All the other courts are inferior to them. So once you get into these courts, before I finish that, I say you got to get those tickets into the Article 3 courts. And when I say Article 3 courts, meaning in the Constitution, in Article 3, it talks about the courts who have original jurisdiction. So really, Article 3 is a slang for Supreme Court or the court with the original jurisdiction, meaning it is the real court. They confer jurisdiction to the lower courts because not it would take that one court would be bombarded with all kind of courts, so they give the lesser courts jurisdiction to hear traffic tickets and all kinds of other stuff. But they could retain jurisdiction by way of appeal, meaning you do all of the things necessary to fight that lower court to get that decision in your favor. Then once that's exhausted, then you do this. In New York, it's called the Article 78 proceeding to challenge the original hearing decision or appeals determination by visiting the clerk of the Supreme Court. So based on this, it's saying you can challenge, you don't have to do the appeal process. You can challenge the original hearing decision and go do this proceeding. So basically, an Article 78 proceeding is a lawsuit. You are suing that lower court over that decision, saying they made some mistake. They didn't follow the Constitution. They didn't follow their rules. Right? So I have a PDF, and it shows you how to commence a special proceeding. Here. It tells you. This is when I typed in, is this the correct one? Let me make sure, New York courts. It says here, a special proceeding can only be used where it is specifically authorized by statute, and in this case, it is. There are a number of these, but generally they relate to challenging the action or determination of a governmental officer or agency. Those courts are a government agency. Those lower courts. See Civil Practice Law Rules, CPLR for short, Article 78. So they even give you where to go to see the rules. I always tell you guys, know the rules. Don't go in there with your own rules. Don't go in there with those Moorish rules. Don't go in there with those sovereign citizen rules. Go in there with the rules that they have because that's their playground and it has rules. You can't go in somebody's playground and make up your own rules. Okay? You have to figure out what the rules are and use those rules to your advantage. I just had a consultation today with someone who actually they're suing the lower courts. They're suing the court for, they got pulled over. Actually, it was what you called a what do you call those things? Those roadblocks that they do, and they just want to check everybody's things. Y'all do know that those are unconstitutional actions when they're just doing a roadblock and randomly checking people's stuff. That's against the Constitution. And the Constitution specifically says that, right? Let's pull up the New York Constitution real quick before I go back to that. This is the New York Constitution. It's on PDF. Effective January 1st, 24, as revised, including amendments, effective January 1st, 2024. So that means they just made some amendments to this thing. And I'm going to tell you, I've looked at a lot of constitutions, and New York's is one of the worst constitutions that I've ever read. But even though it's one of the worst I've read, it still has information in it that you can use to support yourself and defend. So, scroll down. I would download this thing if I was you, especially if you lived in New York. So the one I'm looking for is think it's right privileged friends, power of legislation, trial by jury, freedom work, bail, fines, punishment, grand jury protection. 9 equal security against number 12 of Article 1 Bill of Rights. Number 12. So let's go down to read number 12. But these things are, if you have time, read this. You'll find some interesting things in there. The Constitution for any state is what you call the bylaws or the trust indenture, the expression of the trust, or how this Constitution, how that state will run its state. For every officer, what they have to uphold. They take an oath to this, to uphold and to defend this. But we know that they don't uphold or defend it at all. What they uphold and defend is codes and statutes. Okay? And the first thing, this is why, when I always look sideways at people who want to tell me that it's ridiculous for me to use religious freedoms in my paperwork. Well, the Constitution they use religious freedoms. Here it is. It says, we the people of the state of New York, grateful to Almighty God for our freedom in order to secure its blessings, do establish this Constitution. It says grateful to Almighty God. So there it is. That one statement makes this a religious document, a religiously protected document. Just putting that in there. No one can question that. They're doing it. How come you don't do it? No one can tell, wait a minute. They said this is about Almighty God. Hey, okay, no questions asked. You can't challenge that. Right? Then at number 3, they talk about it. Free exercise and enjoyment of religion, profession, and worship. Why would they put that in there? Because they were religious folks themselves when they created this. So they put something in there and say, hey, we have the right, and so do you, to express your religion freely. Without discrimination or preference, shall forever be allowed in this state to all humankind, and no person shall be rendered incompetent to be a witness on account of his or her opinions on matters of religious belief. That's a very profound and important statement. It says you cannot be rendered incompetent to be a witness on account of his or her opinions on matters of religious belief. So if you go into court and you say this is my religion, they can't render that statement incompetent. All right. But it also say, but the liberty of conscience hereby secured shall not be so construed as to excuse acts of licentiousness or justify practices inconsistent with the peace and safety of this state. So you can practice your religion whatever you want, as long as it doesn't interfere with anyone else's peace and security. All right. So let's go to 12. 12. Right here. The right of the people to be secure in their person, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person of things to be seized. So when they're doing traffic stops, right? When they're doing those roadblocks, it's another name for it, I think. But when they're doing those things where they're just randomly checking people, that violates Section 12 of Article 1, Bill of Rights of the New York Constitution. Violates it 100%. Because now you're stopping me, you're asking me questions, give you idea, and you didn't commit any crime. They didn't see you. You're just minding your business. So they insert themselves into your personal affairs. Why? Why do they want to see ID? Because they want to do a roadblock so they can find something. They are searching you, looking for you to give them something to incriminate yourself. Totally unconstitutional. You see, now the individual I'm talking to, they refused to give up their ID, all of that stuff, because they said, did I commit a crime? They said no. Well, then I don't need to show you anything, and they were right. To me, at that point, I'd be like, I don't talk to cops. I have the right to remain silent or give anything that will incriminate me. Right? So I won't go into all of what happened, but what I like about the New York Constitution is this second part of this Section 12. It says the right of the people to be secure against unreasonable interception of telephone and telegraph communication shall not be violated. And ex parte orders or warrant shall issue only upon oath of affirmation that there is a reasonable ground to believe that evidence of a crime may be thus obtained, and identifying the particular means of communication and particularly describing the person or persons whose communication ought to be intercepted and the person's purpose thereof. So they have rules on intercepting your phone calls, which I don't know any other constitution that specifically talks about telephone calls or, intercepting your communications. And they say ex parte. Ex parte means the one party is going to get this warrant or order without the other party's knowledge. So I mean, one party is like a proceeding that they won't know about, but they have specific rules. They have to, hey, this is the grounds. This is why we think we can get it, and lay it out. But you know how these entities are. They'll just give it, they give those things out like candy probably. But they have rules for it. Now, and even they have in number 13, they talk about purchase of Indian lands, which is interesting. But we're not talking about that tonight. So let's go back to that, what I was reading. Landlord-tenant relations can also be determined in special proceedings in some instances. Otherwise, special proceedings usually cannot be brought against private parties. So this proceeding is specifically to be used against governmental officers and agencies. This is how you sue them. Okay? If you are unsure whether or not your matter is considered a special proceeding, it is suggested that you consult with an attorney to ensure that your facts support your claim. If it clearly doesn't support your claim could be dismissed with a sanction as frivolous. By signing a paper such as a petition, that party certifies that to the best of his or her knowledge, information, and belief, the presentation of the paper or the information contained therein is not frivolous. See Rules of Chief Administrative Judge, Section 130-1A, signing of papers. So that's why you have to be real, very careful about how you proceed with these type of proceedings, because they can say it's frivolous. So you going in there trying to use all those sovereign citizen and those Moorish arguments, then you're going to get hit with sanctions and they're going to say it's frivolous. But if you go in there using their document, which is the Constitution, to support your suit, that's not frivolous. Hey, they did a roadblock and they just arbitrarily just asking me for stuff and I didn't commit a crime. They violated this section of the Constitution. All right. The person bringing the case called the petitioner, while the party opposing the petition is called the respondent. So you would be the petitioner and they would be the respondent. The petitioner should be sure that he or she brings the special proceeding in the proper county. So you got to bring it in the proper county. There are a number of rules about what is proper venue for a case that generally relates to the residents of the various parties and where the underlying. Oh, I didn't even open up the Telegram. That's what happens when I'm thrown off. I'm opening it up now. There you go. It's open. There we go. People jumped on right away. Let me put it in the chat too. There's a live stream on Telegram if you want to talk to me. All right. Where was I? Generally, the petition must commence a special proceeding against a public body or officer in any county within a judicial district where the respondent made the determination complained of or refused to perform the duty allegedly violated, where the underlying proceedings were brought, where the material events took place, or where the principal officer respondent is located. The 6th Judicial District covers 10 counties: Broome, Chemung, Shenango, Cortland, Delaware, Madison, Otsego, Schuyler, Tioga, and Tompkins. To commence a special proceeding, you need to file the following with the county clerk's office. Let's do this. County clerk's office. 1, notice of petition or order to show cause. So you can do one or the other. Verified petition. Look up what a verified petition is. A petition, you do the petition, you got to sign it saying you verify everything in there is true and correct under penalties of perjury. Application for index number form and request for judicial intervention form. The fee to obtain an index number is $210, and the fee for the RJI is $95. So it's about $300 to do this. $305. Please check with your local county clerk's office to see what forms of payment are accepted. If petition obtains a poor person's order, these fees may be waived. Only a poor person, as defined by law, may be exempted from the obligation to pay these fees. A notice of petition is directed to, respondent advises where and when the petition is to be submitted to a Supreme Court justice and identifies all papers upon which the special proceeding is based. An order to show cause also serves to give notice to all parties, but the form of the document is different. Unlike a notice of petition, it is presented to a justice and signed by him or her before it is served on the other parties in the case. So it said you could bring a suit against the officer as well who wrote you that ticket, who violated the rights. I would definitely go after that officer for sure. The petition. In order to commence this kind of lawsuit, see, they calling it a lawsuit. You're suing them. A person must prepare a document called a petition, which is a statement of the person's charges or the grievance of which the person complains. A petition and any other document served in this court should be typed or legibly printed in English in black ink on 8.5 by 11-inch paper using one side of the paper only. Paper should be stapled or otherwise bound securely. And they got a rule for that under CPLR section 2101. The petition should have the name of the court and county, the caption of the case, a box at the top containing the names of all parties, and the index number and the identifying number explained below on the right side. The petition should begin with the brief identification of the petitioner. This should be allowed by identification of the respondent. The respondent name should be those persons claimed to have made the determination or decision at issue. So basically what they're saying is whoever made the decision is the person you need to name that named them. The petition should set forth a brief factual description of the determination or events upon which the claim is based in chronological order, including the dates of key events. Each allegation set forth should be in separate numbered paragraphs. I mean, they're just telling you exactly how it need to be done. So anybody that want to use this, I'm not going to read all of this. And they got statute of limitations on it, so you need to read that. All right. So there you have it. That's enough. I've read enough. I gave y'all enough to figure that out for yourself. Let me see. Get my camera back. So there is remedy from these courts that violate you. You know, because I've known plenty of people gone to these courts and they always lose. And then because they don't know how to go at them, they give up. And that's what they're banking on. You giving up. You see? That's what they're banking on, that you will just give them the money. And that's why they throw all of these convoluted processes in your way so that you don't feel like it's worth the time. I could be doing something else. This is too much. But, enough is enough, man. Some things you do, it is worth your time to fight. First of all, it's going to teach you something. You're going to become self-sufficient in learning how to navigate this system. That's our issue. Most of us just don't know how to navigate this system. We weren't taught that. I get it. But you could teach yourself. I taught myself. I don't know everything, but I know a great deal to navigate the court system. And what I don't know, I go look it up or I go to someone that can help me. Now, one thing I've always given y'all this link. I put it in the chat. That how to win in court. That guy, he's a lawyer. He teaches you how to win. I'm gonna put it in the chat again, and I'm gonna put it in the Telegram chat for you guys to get. What is going on here? All right, there it is. How to win in court. It's in Telegram. Click that link. It's only $2.49. Then it's like 89 every year to renew. That is a small price to pay to be how to know how to beat these guys at their own game. Very small price to pay. All right, so let's go to the chat. It's 8:15, 45 minutes. I've been on already. Man, it don't even seem like that. I've been on that long. Lucan Apple says, peace to the gods and much light to all. Indie Circle said, peace, my brother. And there's the link for how to win in court. And who else is on? Javier, peace. He said, peace and prosperity. Same to you. Cacnet says, peace to all. And Lucan Apple said he printed out that thing I was reading, that document that I was reading, not that thing, the document. So there you have it. If you got something to say, you can either put it in the chat online or you could do it on Telegram. Raise your hand and I will open your mic up. I have gotten all of the audio things worked out and we should be fine. All right. I'll give you all a second to think about it. Give you a second. No questions, nothing. Sure, I done my job. I'll get off and enjoy the rest of my evening. Now, what led me to talk about this? Well, a couple of weeks I've been wanting to talk about it, but someone who I had a consultation with today, they got one of those road checks, where they check or roadblocks. They refused to give up the information, and what happened, they ended up going to jail, then got out, case got dismissed. They went in, so they wanted to sue. They went into the lawsuit phase, and they, first stop was those Moors. And one of the complaints was with the Moors was they were very arrogant, and whenever the person asked them questions, they got angry with them and tried to treat them like they were stupid. Even tried to say that they was from, like, allude to their intelligence, made reference to their intelligence not being good. And I'm like, listen, don't let that stuff get to you, because the reason why they talk like that, because they don't know what they're talking about. They're taking money from you to fight something, and I can guarantee you they have no proof of any success that they've had with their teaching. And see, one of the things they were talking, the person I was doing a consultation with, they were saying that their paperwork was very combative, and they didn't want to go into court like that. They just wanted to state the facts and why they should win this lawsuit. She's suing them for like $10 million, some big number, right? Which is good, right? And they had all of this language that was very hostile, and they said, no, I don't want to be hostile. I just want this. And they got mad. This is where I'm doing it. And it's like, I said, listen, you don't need to be hostile when you're doing your assault. Do you see lawyers' paperwork when they do it? It's not hostile. See, when you go into court with these types of tactics, sovereign citizens, the Moors community, and I'm talking about specific to not all Moors are bad, but there's a specific segment of these Moors, these people who call themselves Moors, that go in and act like they're gangsters. And they want to assert all of these unfounded, baseless statements. I don't even want to use the word facts to that stuff, right? Because I'll say baseless and then put facts. I mean, they don't go together because they're not facts. They're baseless arguments, nonsensical arguments. And the court will deem you hostile and treat you with extreme prejudice once they do that, because they got two groups that they consider terrorists amongst this: sovereign citizens and the Moorish science people. Those two groups, they consider them paper terrorists, domestic paper terrorists. And the word on the street, the bulletins they send out, treat them with extreme prejudice. So once you get into court and they see that you're doing that, they coming at you hard. And they're gonna ignore your paperwork. And then they gave her like a book to file. You don't need a book. You just need what they're asking for. That's it. Now, with this 7(a) proceeding, I like my paperwork to be no more than 1-2 pages long. But the way they, based off I'm reading, you need certain things. It's gonna be more than 1 page, more than 2 pages. The way it looks, you got to get notice of petition. A couple of things they were want you to do, and that's just New York, because they have a funny way you need to file paperwork and things like that. Now, if I'm going to go after them and sue that court, I'm definitely going to ask for my money that I paid to file a lawsuit back. Recover that. Not only am I going to recover what they're charging me in fines, plus recover my court cost. Now, people say, well, why don't you go in as a pauper and all of that, foreign pauperist, whatever that is. I would not do that because that's for U.S. citizens. So I would say just pay the fee, or you could do this, but it'll prolong the process. Find the part of the Constitution saying that your court costs should be free, because some constitutions say that. I'm not sure if New York says that or not. I'm not sure if it says it or not. I know there are several states where in their constitution they say court to defend yourself or to go get seek what you call in your grievances, you shouldn't have to pay. So look that up. If you want to go down that road. Me, I would just go ahead, just to speed things along, pay the fee, and then include it in as a recovery in my suit. And I'll be naming whoever I can name. I'll name the judge, all of them, the state, because it's their codes and statutes they're following, and even the officer if I can. But when I was reading it further along, it said you need to name, if you're going to name anybody, you need to name at least that administrative judge who made the decision in the complaint as the respondent. Okay. In combination with 78 proceeding, what are you talking about, Luke and April? I'm not sure what you're saying when you say in combination with 78 proceeding. I wonder. I don't get what you're saying. Notice of appearance and motion to dismiss apply in any way. Okay, see. This is why you need to, no offense, you need to go and get that How to Win in Court software. Notice of appearance applies, But motion to dismiss, what are you going to motion to dismiss? For what? Motion to dismiss is if you are being sued and you wanted to get dismissed. Why would you put a notice to dismiss in if you're the one instituting the proceeding? You're the one who is the petitioner. So that wouldn't that's why I would suggest you get that software, $250, pay it, man, and study, and you'll understand why I'm saying what I'm saying. Notice of appearance is okay if you want to put it in there, but you're conducting a suit. Be careful what you say in your notice of appearance, or you don't appear like you're a sovereign citizen. And that was one of the questions I was asked today. Oh, should I do by special appearance and all of that stuff? No, man. Those people put on all that by special appearance, and they by special appearance lose still. I've never, ever, none of my paperwork ever, you never saw me say that. I never said by special appearance. See, y'all got to remember, all of those other groupies are doing that. So once they see that, boom, up, sovereign citizen. Oh, this is the Morris Science Temple people. And everything else is they not looking at. Okay? Listen, when y'all coming to my platform, I need y'all to erase some of that stuff out of your head. Because I don't run like that. I don't move in those cases. This is why I get the success. I move different, but at the same time, I look like them. I blend in. Isn't that how they were able to walk around in the Matrix? Neo, Trinity, Morpheus. Although they had on some cool gear, they blended in until they did some superhero stuff, and then they didn't blend in no more. But for the most part, they blended in. The Morris Science Temple and all them other knuckleheads, they don't blend in, and this is why they got problems. And because they don't blend in, they created a rule for these non-blended in people. We gonna treat them with extreme prejudice. We're gonna slam them when we see them. We're gonna treat them like, we're gonna treat them harsh. Blend in. Get that through your head. Basically, that stuff they've been teaching for what? Me, I've been around 10 years, and I'm sure it's been around a lot longer than 20, 30, 40 years of these teachings. And they just keep grabbing new victims. People who don't know better, and they feel so great about the information, because this stuff can really grab a hold of you and get you, wow, it sounds so great, because you're so wanting to get out of the system and get some freedom, that this sounds so great. But you can get freedom, but most of the people that are teaching this stuff are really in bad shape financially. And this is the only way they can make money, so they come at you to get money out of your pocket. And this woman paid $1,500 here, there, and she had to cut them off because they were treating her bad. And when she was just telling me what she was talking about, and I was like, okay, this is all you need to do when you do this lawsuit. Couple of things here, and I'm gonna look at her petition, but she's almost a year in, so amending the complaint will become a problem, because that's gonna start everything over. The respondent's gonna have, you reset the clock. The respondent gets time to answer the amended complaint. So I just hope that her complaint looks, what the word I want to use is, it's a word that the court would use. It's a word for making sense. but they use that word. They use a word called it's a word, I can't think of that word they use when they say it's illegible, or I can't think of the word right now. But you want your complaint to make sense, and you want to get to the point. Like she was mentioning, yeah, I sent them all affidavits. They didn't answer my affidavits, and I had to explain to her. They don't really have to answer an affidavit because you're not giving any orders. Now, they do need to rebut an affidavit, but an affidavit usually is support. Okay, let me give you an example of how you would use an affidavit. See, this is one of the things that was taught, and I got this teaching when I came in. Oh, yeah, throw an affidavit in there. Affidavit of truth, affidavit of that, affidavit of whatever, right? But if you notice lawsuits, it's got a complaint and it's supported by an affidavit. An affidavit is a support document. An affidavit is stating the facts as you know it, your firsthand knowledge. Whether it be a statement of what you witnessed or a document that supports the facts that you're using. Hey, I have a document that says this, see Exhibit A. So an affidavit typically doesn't go in by itself. It goes in. Say if you're being sued, right? You're sued and you want to respond to their complaint. So you would have rebuttal or objection, response and objection to complaint. That's just generalizing, and then you would state your response to their complaint, and then you would attach an affidavit of your side of the story to it. Affidavit in support of response to complaint. Things like that. Because that's how when they sue you like for a debt, they'll have their complaint, outline all of your charges or their grievances, and then they will have an affidavit to support that complaint. So we have to get out of the mindset that we need to just throw an affidavit. Okay, you got an affidavit in it. And she was wondering why she wasn't getting a response. No, because you didn't trigger a response. Because you didn't have it attached to something for them to respond to. See, now once I put in my response in objection, my response to their complaint, boom, and then put my affidavit in it, now I just triggered, because on the paperwork it says response. Or it says answer to complaint. One of the other, you can say response or answer. See, that triggers, hey, he's answering my complaint now. Now I got to respond to his answer, rebut it. And now that they got an affidavit, because now the affidavit becomes the fact, meaning those are my facts, and I'm saying those under penalty of perjury, because I'm signing off. An affidavit is structured in a specific way to become basically sworn testimony. Right? That's how the court looks at it. And they have to rebut that. All right? But you need to get that. I'm just giving y'all a summary of what I know. How to win in court. Very good. It's going to take your time, and it has a quiz after every section. $250 to be taught by a lawyer who's been through, guy had a bar card and all of that stuff, who is totally against this current system. That's how I learned. I stopped listening to these Moorish communities and these sovereign citizen people because I saw one thing. I remember when I first started this, And I used to meet every Saturday down at Solomon's Temple with a bunch of brothers, and we used to sit around and talk about different things. I was new. And when I was learning it, my buddy Solomon, who runs the store, he's like, man, don't mess with those guys. They always going to jail, this and that. He said, man, please, I beg you. He was begging me not to mess with them, right? Not listen to him. But I still would just listen. But, he didn't know me well enough. He didn't know that I don't just follow people. I just listen and listen. I was curious. I just wanted to know and listen and listen and listen. And I was observing who was telling me the information. 99% of the guys talking were people with jobs, and they, most of them was living hand to mouth. And I'm saying, y'all know all of this about how I could discharge debt. I could do a list, but y'all, how are y'all discharging debt? Anybody y'all know? Then they mentioned one guy, and then he ended up going to jail. You see? And then one day I went to Solomon. I said, man, I'm going to disassociate myself from these guys. Because here's one thing I know. I think the information is something to understand and know. But I'm looking at these guys. None of these guys got good fruit. So only thing I can learn from them is bad things. That's what I told him. And then when Hindsight Radio was in its infancy, when it first started, I said on my show, I told this very story, and they all got pissed and they stopped talking to me. And most of them are still in the same position they was almost 10 years ago. Why are they in the same position they was almost 10 years ago? Because they assumed the information they got was 100% correct. Me, I didn't assume that. I tried trial and error, and when it didn't work, I looked for other methods of information. I started to read and research and read these things for myself, and then I realized how he's teaching it doesn't match up to what this says. I found a lot of that over those years. Y'all go back, go on Blog Talk Radio to the very beginning of the shows too. In your free time, just turn on Blog Talk Radio and go to all of the shows and listen to them. And you'll find one common theme, especially when it comes to my shows. People were coming on giving testimonies when they came to court with my help from my consultations. I'm 100. Go check it. I ain't got to sit here and say, yeah, I did. No, go listen to the shows. There's still some good information in there. Go listen to them. And it continues to happen. Why? Because I'm pulling out this stuff, I'm reading, I'm dissecting it. Now I have not only reading, I have experience in it. In doing these things. That's how when people tell me, no, there's no remedy, there's no thing. I said, no, there is remedy. You just haven't found it yet. You haven't sought the information in the right area. You haven't looked deep enough. Like I found that page when I talked about it a couple of weeks ago. Then I'm trying to find it tonight or today, and I couldn't find it. But I had to put in the exact search criteria that I did the first time, and that's how I was able to pull that page up. But if you just go to it in general, you would never see that page. Y'all think that's by accident? No, it's by design, so that you don't find it. Just like this system. All of the bad results that we call bad results that the system is producing, that's just us defining or giving it the definition of bad. But it's producing the results it wants. This system gets the results it wants. It's designed to produce what it's producing. So the moment you realize that this system is designed to give the results that is given, you say, oh, okay, this is what the system wants. It wants illiterate people. It wants people to opt for jobs rather than entrepreneurship. Because people with jobs make the world go around. They're the ones who are going to pay most of the taxes. Without those regular people, the government can't make any money. Okay? They need the birth certificates and the social security numbers to have people in their entities in their jurisdiction that they can tax. Period. So when they say you got to have this and you got to have that, yes, you have to have it for their benefit. It's no benefit for you to have their birth certificate, really. Think about it. Every time you show it, it's for something they want you to do. Right? It's interesting that when you go for a passport, that's one that they say show that, but that's not the only thing you need to show to even get a passport. You don't have to have a birth certificate to get a passport. We assumed it. Why? Because that's what they have. Where's your birth? That's people's program to say, I need your birth certificate. And then you got to tell them, I don't have a birth certificate. This is what I have. You know, wait, no, I need the birth certificate. And then you got to show them, well, this says I can show this. That's why I'm really advocating now that don't go to the post office or these regular places to get your passport. Go make an appointment to go see them. Go set up an itinerary to go to like Canada, Mexico, go. All you got to do is book a hotel. You don't have to, most hotels don't ask you to pay for anything up front, so you can get your money back. Right? What I'm saying, book it where you can get your money back, and then go make an appointment to go sit with them. And now you can put all your rights in front of them. Now they got to tell you to your face no. They can't do it behind the screen, behind the mail, where you go into the thing, you fill it out, and hope they send everything back. Because the next phase of where I'm going, it's going to require you to go sit down and talk to them. Because I'm starting to now, I'm starting to believe and know that the real status correction is to go before them. Do y'all know that nah. I was about to say it. Nah. I'm about to blow your mind with something. I ain't saying it until I get into I'm gonna tell my people they deserve to hear what I'm about to say first. And people in my premium membership group, remind me to talk about it at the next meeting. And then I'll say it on the air. Because if I say it on the air now, everybody and their mama will be talking about it when they get on their shows and they go, oh, I figured this out. There was a status correction proceeding going on in the Bible. I'm going to leave it right there. I'm going to leave it right there. Okay? And I'm going to break it down in my next seminar. See, we've been dealing with status correction from a biblical point of view. And there was somebody that stood that status correction. Had to. All right. I want to say it so bad, but because I know if I said it, everybody would be like, wow, whoa. Y'all it would totally blow your mind. But I owe it to my premium membership people to tell them first. I owe it to, because they've been faithful. They give me their money every month. They keep me in business. So I'm going to hit them up. And if you're not part of the membership, you need to sign up. Because good things is always happening. I'm always breaking down new stuff. I almost blurted it out because I was flowing and it hit. Do y'all know that such and such was a nah? All right, let me open to somebody on King Law. Hold on, let me do this. All right, King Law. Allow to speak. All right, King Lou, I'm sorry. You need to unmute yourself. If you know how. I got you ready to speak. Come on, bro. It's 8:45, man. I'm an hour and 15 minutes in. I just ran my mouth for damn near 25, 30 minutes just now. Didn't realize it. I can go. King Lou, we waiting. King Lou, if you can't get your mic open, just type whatever you have to say in the chat if it's just a simple question. Because I got you ready to roll, but you're not rolling. Somebody said I'm with you. There was a couple of status corrections in there. Yep. Javier says facts. I guess King Lou ain't ready. He maybe hit the button by accident. I was hoping he had something to say. He's supposed to be listening. All right, well, you're gonna have to miss out because I'm about to be out of here. Because if I stay on any longer, I might let the cat out of the bag, and I don't want to do that. All right, King Lou, that's it. You had your chance. Oh, you had your chance. All right, with that being said, y'all have a good night. I will see you guys on Sunday, 10 a.m. Sunday, 10 a.m. Peace, prosperity, extreme wealth to all. Read that scripture, that kind of like, how would he curse a tree that wasn't bearing fruit, but it wasn't supposed to be bearing fruit? Now, when I heard Reverend Ike preach on it, he said, well, anything that doesn't produces any fruit, what's the use for it? He went to the tree to get the fruit. There was no fruit. And he said, may no one get fruit from you. So let's look in our life. How many times, or apply it to yourself? Maybe you're the tree. Maybe it's the message in that is that you're the tree that is supposed to bear fruit, but all you have is leaves. All you have is, what are leaves? You keep, the leaves weren't edible. He was looking for the fruit. Are you just a person who just stands there and just look pretty, look handsome, but you're not bearing any fruit? You're not producing anything of value. And what I mean by of value, are you producing anything value for yourself, for self-improvement? Because in order to improve anything, you have to improve yourself. The first job that you have is to improve yourself, to make yourself better for yourself so that you can be better for the world.